April 24, 2018, Sacramento County Superior Court. A clerk timestamps a warrant packet at 9:47 in the morning, the first arrest built entirely from genealogy databases. For decades, cold case detectives promised families that DNA would deliver answers. The record shows something different. Evidence degraded, backlogs stretched years, and state laws diverged wildly on what investigators could actually do with a genetic match. 7 homicides, offense windows spanning 1974 to 1998, sentencing outcomes from 2003 to 2020. Some defendants received life without parole. Others negotiated pleas shaped by age, mitigation evidence, or the simple fact that families could not endure a trial. The technology arrived at different speeds across jurisdictions: Iowa, California, Pennsylvania, Kansas, Washington. This is a story written in filings, vote tallies, and status updates, about justice deferred, then delivered, and about the quiet line in a court order that changes everything. June 29, 2020. Sacramento. A courtroom clerk distributes copies of a sentencing packet running 214 pages. Hours of victim impact statements have already been read. Families sit in rows, some holding photographs from decades earlier. The public expected years of appeals, motions, retrials, the full machinery of capital litigation. The record shows a negotiated closure. Joseph James D'Angelo, 74 years old, pleaded guilty to 13 counts of murder and 13 counts of kidnapping. Crimes committed between 1974 and 1986 across multiple California counties. The sentence: life without possibility of parole. LWOP, life without possibility of parole, means no parole board will ever review the case. No hearing, no release. The plea avoided the death penalty. Defense counsel cited age-related medical conditions. Prosecutors emphasized a single priority: preventing re-traumatization of survivors through a prolonged trial. Dozens of families would have been compelled to testify. Cross-examination, evidence presentation, years of continuances. DNA finally answered the question of who. Genealogy databases traced distant relatives, narrowing a suspect pool to one man. But the state still negotiated rather than pursue full trial exposure. The plea agreement closed direct appeals. Appeal posture, the formal procedural stage of a case, determines what legal challenges remain available. Direct appeal, the first review after conviction. State post-conviction, claims of ineffective counsel or new evidence. Federal habeas, constitutional challenges in federal court. Clemency, executive action by a governor or board to commute, pardon, or issue reprieve. D'Angelo waived direct appeal rights as part of the plea. The docket shows finality within months, not decades. A spokesperson for the Sacramento County District Attorney's Office read a prepared statement. This resolution honors the victim's need for closure while ensuring the defendant will never walk free. One family member spoke briefly to reporters outside. We wanted him to face everything he did, but we also wanted it to end. If DNA solved the identity question with near certainty, why did the state still choose negotiation over courtroom confrontation? April 16, 2018, Fort Wayne, Indiana. An evidence technician opens a file marked Tinsley April Marie, 1988. Inside, a swab taken from a garage door handle, preserved for 30 years. A genealogy database comparison produces a list of distant relatives. The names converge on a single surname, one address in rural Allen County. The public expected a dramatic chase, surveillance teams, a standoff. The record shows a quiet knock on a trailer door. John D. Miller answered. Officers requested a voluntary DNA sample. He complied. The lab confirmed a match within days. April Tinsley was 8 years old when she disappeared on April 19, 1988. Her body was discovered 3 days later. For 3 decades, the case file remained open. Periodic reviews, dead-end leads. Then, genealogy technology arrived. Miller was arrested on July 15, 2018. He pleaded guilty to murder and child abduction in Allen County Superior Court. Sentencing, 80 years. He waived direct appeal rights in exchange for avoiding a trial that would have required forensic testimony about the child's final hours. Mitigation, evidence intended to reduce culpability or sentence severity, was not offered. Defense counsel did not contest the forensic findings. No mental health evaluations entered the record. No alternative theories proposed. The charging documents cite DNA probability, 1 in several billion. The genealogy lead reduced a theoretical suspect universe to a confirmed identity. But genealogy is investigative, not courtroom evidence. The confirmatory swab, taken with consent, provided the admissible match. A detective testified at the plea hearing. Without the database, we had no path forward. The evidence was strong, but we had no suspect. Mitigation can include documented mental illness, intellectual disability, childhood trauma, or age-related cognitive decline. Miller's defense team introduced none of these factors. The plea hearing lasted 40 minutes. When genealogy reduces a suspect list to one name, should the law treat the resulting arrest as near certain or merely a starting point requiring traditional investigation? March 9, 2019. Lynn County, Iowa. A judge reviews digital motions in State v. Burns. The defense argues that DNA collected covertly from a drinking straw violates Iowa's constitutional privacy protections. Prosecutors counter that items discarded in public spaces carry no reasonable expectation of privacy. The case traces back to December 19, 1979. Michelle Martinko, 18 years old, was found dead in her car in a Cedar Rapids shopping mall parking lot. Blood evidence was preserved. For nearly 40 years, the case remained unsolved. In 2018, investigators uploaded the crime scene DNA profile to a genealogy database. The results pointed to a family tree. Officers identified Jerry Lynn Burns as a potential suspect. They followed him to a restaurant, waited until he left, then collected a straw he had used. The lab confirmed a match. Burns was arrested on December 19, 2018, 39 years to the day after Martinko's death. He was charged with first-degree murder. Trial began in February 2020. He was convicted. Sentence: life without possibility of parole. The Iowa Supreme Court is reviewing his appeal. The central question: whether covert collection of abandoned DNA meets state constitutional standards. Federal courts have generally upheld such practices under the Fourth Amendment. State courts vary. The trial record includes expert testimony on DNA degradation. After nearly 4 decades, portions of the original sample were barely usable. Testing consumed much of the remaining material. Defense counsel argued that future retesting, should new technology emerge, would be impossible. Appeal posture matters. Burns is in state post-conviction proceedings. If the Iowa Supreme Court denies relief, federal habeas review could follow. That process typically adds years. A brief mitigation statement was presented at sentencing. An expert testified about age-related adaptive functioning. The court found the evidence insufficient to alter the sentence. The public expected the case to hinge on confession or eyewitness testimony. The record shows years of litigation around privacy boundaries and surveillance methods. If the evidence is strong but the collection method is novel, how much weight should courts give to procedure over closure? June 12, 2014. King County, Washington. A medical examiner's office updates a cold case spreadsheet. A degraded bone fragment from a remain site has yielded a CODIS hit, the FBI's combined DNA index system. The name belongs to a woman reported missing in 1983. Her family is notified 31 years later. Gary Leon Ridgway pleaded guilty in November 2003 to 48 counts of aggravated murder. Sentence: life without possibility of parole, avoiding Washington's death penalty. The plea agreement included a provision: if Ridgway provided information leading to additional victim identifications, he would not face new charges. He kept his side of the agreement. Over the following decade, forensic teams revisited remain sites. Some identifications required mitochondrial DNA. Others relied on dental records. By 2015, several previously unidentified victims had been named in amended court filings. LWOP, life, without possibility of parole, means Ridgway's sentence was already final before full victim accounting. The additional identifications did not change his legal status, but they changed the record. Mitigation played a role in his original sentencing. Expert witnesses testified about limited cognitive functioning. Psychological evaluations documented adaptive deficits. The court acknowledged these factors while emphasizing the scale of the crimes. 48 murders across 16 years, spanning 1982 to 1998. Post-conviction forensic review clarified cause of death classifications. Some remains had deteriorated to the point where trauma analysis was speculative. DNA closed the identity question, even when the manner of death remained uncertain. Unlike D'Angelo's single sweeping arrest, Ridgway's case unfolded incrementally. The original plea covered known victims. The later identifications revealed a sentencing already fixed before the final count. A spokesperson for the King County Prosecutor's Office explained the protocol. Each identification requires family notification, court filing updates, and memorial acknowledgement. The legal resolution is settled, the human accounting continues. If a sentence is already final, how should the justice system honor newly identified victims without reopening settled cases? August 7, 2018, Lancaster, Pennsylvania. Detectives compare a genealogy database lead with DNA obtained from a discarded water bottle. The bottle was collected at a public performance venue where the suspect worked as a disc jockey under the name DJ Freeze. Raymond Charles Rowe was arrested on June 25, 2018. He was charged with the murder of Christy Marac, a 25-year-old teacher killed in her home on December 21, 1992. The case had been cold for 26 years. Genealogy analysis pointed investigators to Rowe. They attended one of his public DJ performances, waited until he discarded a water bottle, then retrieved it. The DNA matched crime scene evidence. Rowe pleaded guilty in Lancaster County Court on March 22, 2019. Sentence: life without possibility of parole. A procedural dispute emerged over whether covert collection at a public workplace meets privacy thresholds under Pennsylvania case law. The state Supreme Court has addressed abandoned property doctrine in traffic stops and residential trash collection. Public venue DNA retrieval occupied newer ground. Defense counsel referenced Rowe's long-standing community ties. He had maintained a visible public career for decades. No psychiatric mitigation was offered. The plea hearing focused on forensic certainty and victim family impact. Appeal posture indicates where a case sits procedurally: direct appeal, state post-conviction, federal habeas, or clemency. Rowe waived direct appeal rights as part of his plea. The docket shows finality. Within months, Rowe's public-facing persona contrasts with Burns's low-profile life. Both were identified through genealogy. Both cases involved covert DNA collection, but community shock levels differed sharply. A detective testified that tips and leads dried up in the Burns case after initial publicity. In Rowe's case, the arrest itself generated renewed attention. Families who had hired him for events expressed disbelief. The public assumes suspects in decades-old cases go quiet. The record shows some maintain prominent careers, complicating community expectations. Should covert DNA retrieval at public events require new legislative standards, or do current privacy doctrines already strike the right balance? January 8, 2005, Sedgwick County, Kansas. A forensic analyst cross-checks DNA from a medical specimen belonging to the suspect's daughter. Officers sought a familial comparison after digital evidence, metadata from a floppy disk, led them to Dennis Lynn Rader. Rader was arrested on February 25, 2005. He was charged with 10 counts of first-degree murder committed between 1974 and 1991. He pleaded guilty on June 27, 2005. Sentence: 10 consecutive life sentences. Kansas had abolished the death penalty during the relevant period. The public narrative emphasizes DNA as the breakthrough. The record shows DNA was confirmatory. Digital breadcrumbs, floppy disk metadata traced to a church computer Rader used, were decisive. He had sent taunting letters to media outlets and police for years, resuming contact in 2004 after a long silence. A legal challenge emerged concerning familial DNA acquisition. Defense counsel argued the search warrant for the daughter's specimen violated her Fourth Amendment rights. The Kansas Supreme Court ruled that law enforcement acted within constitutional bounds. The daughter was not the suspect, and the sample was obtained through standard legal process. SHU, Special Housing Unit, and SAMS, Special Administrative Measures, are high-restriction housing and communication controls sometimes applied to high-profile inmates. Rader is housed under heightened supervision. His mail is monitored. Phone access is limited. These measures reflect ongoing public safety assessments, not additional punishment. Mitigation evidence was entered at sentencing. Psychological evaluations documented personality traits consistent with certain diagnostic criteria. The court acknowledged the evaluations, but found mitigation insufficient given the scope and duration of the offenses. Rader's case demonstrates how combined forensic paths reinforce identity. Behavioral analysis narrowed the suspect pool. Digital evidence provided a name. DNA confirmed it. No single tool was sufficient alone. A prosecutor stated at sentencing, "Technology answered the question of who." The question of why remains beyond our reach. When DNA is confirmatory rather than primary, how should courts weigh the mix of digital and biological evidence in defining certainty? September the 19th, 2023. A state crime lab uploads an aged DNA extract into a combined genealogy database. The sample originates from a 1987 homicide. No suspect has ever been identified. The database populates a distant family tree, third cousins, fourth cousins, branches spanning multiple states. This represents the pre-arrest phase. DNA alone does not equal a name. Analysts spend months constructing family trees, cross-referencing public records, obituaries, census data. They build toward a suspect list. Then they wait. Questions over third-party consent dominate current litigation. Users who upload their DNA to consumer genealogy platforms agree to terms of service, but their relatives who share genetic markers do not. Should investigative agencies access databases built on consumer consent when genetic relatives never agreed? Pennsylvania, California, and Iowa courts have addressed portions of this question. Answers vary by jurisdiction. Some states require a warrant before law enforcement queries genealogy databases. Others treat the databases as publicly accessible. Abandoned DNA doctrine also applies here. If a suspect discards an item in public, a cup, a napkin, a straw, officers can retrieve it without a warrant. But genealogy databases bypass that step. They identify a suspect before any physical encounter. The unknown predator designation reflects cases where biological profiles exist in CODIS, but no suspect has been arrested. These cases demonstrate how science moves faster than statutory clarity. Labs can generate leads. Courts must then determine whether those leads were lawfully obtained. Federal statistics show genealogy-assisted arrests rose sharply after 2018. State participation varies. Some jurisdictions lack funding for dedicated genealogy analysts. Others face statutory restrictions on database access. A spokesperson for a state attorney general's office explained the gap. We have the science, we have the evidence. What we do not always have is the legal framework to act on what the science tells us. The public believes DNA equals imminent arrest. The record shows analysts can wait months, sometimes years, for judicial rulings on whether investigative methods are permissible. When a biological profile is strong but no suspect is yet identified, what safeguards or obligations should govern investigative genealogy? November 3, 2019. A senior forensic analyst prepares a final extraction from a nearly exhausted evidence swab. The sample originates from a 1978 homicide. Previous testing in 1995 consumed half the material. Retesting in 2007 consumed another quarter. What remains may yield one more result, or it may fail entirely. Defense counsel files a motion, objecting to further testing. The argument, if this final attempt consumes the last usable material, future review becomes impossible. Should new technology emerge in 10 years, technology that could exonerate, no evidence will remain. Prosecutors counter that the evidence exists to be used. Families have waited 4 decades. The chance of future exonerating technology is speculative. The chance of current identification is concrete. The court authorizes the test. The sample yields a partial profile, enough for genealogy analysis but not a full CODIS match. Investigators pursue the lead. An arrest follows. This scenario links back to the Burns and Miller cases. In both, aging samples shaped investigative pacing. Burns's defense argued that testing consumed material needed for future review. Miller's case avoided this dispute. Sufficient material remained after confirmatory testing. Evidence quantity can be exhausted permanently. Unlike digital files, biological samples cannot be copied without degradation. Each test reduces what remains. The choice to test now forecloses future testing. State evidence retention laws vary widely. California requires preservation for the duration of incarceration. Iowa mandates retention while appeals are pending. Pennsylvania allows destruction after final judgment unless defense counsel requests preservation. A public defender testified before a state legislative committee. We are asked to choose between solving a case today and preserving the possibility of exoneration tomorrow. That is not a choice any system should force. The public expects labs can always retest. The record shows finite material, finite opportunities, and finite answers. If the final swab is used today, how should courts protect both victim interests and future evidentiary challenges? June 29, 2020, Sacramento County. The sentencing hearing for Joseph DeAngelo stretches across multiple days. Victims and family members fill the gallery. The court allocates time for each impact statement, some brief, others detailed, all entered into the official record. The plea agreement was finalized months earlier. Prosecutors agreed to waive the death penalty. Defense counsel agreed to plead guilty to all counts without contesting facts. The result? Life without possibility of parole on 13 murder charges and 13 kidnapping charges. Mitigation evidence centered on age and medical conditions. DeAngelo was 74 at sentencing. A defense expert testified about age-related cognitive decline. Medical records documented physical limitations. Family members submitted letters describing his current condition. The court acknowledged these factors, but emphasized the scope of offenses. Crimes across 6 California counties, victims ranging in age from 13 to 41, an offense window spanning 12 years, 1974 to 1986. Victim first principles guided the proceeding. Each family received advance notice of the plea agreement. Each was offered the opportunity to speak. The court scheduled hearings to prevent emotional overload. Survivors did not want a single marathon session. One family member addressed the court. "We wanted trial. We wanted him to hear every detail, but we also could not endure years of appeals, motions, delays. This gives us an ending." The death penalty in California carries automatic appeals, direct review by the state Supreme Court, federal habeas litigation, decades of procedure. Since 1978, California has executed 13 individuals. 720 remain on death row. The median time between sentencing and execution exceeds 25 years. The plea eliminated that timeline. DeAngelo was transferred to state custody immediately. No automatic appeals, no prolonged federal review. Public expectation often favors maximum punishment. Procedural reality includes mitigation weight, victim family input, and resource considerations. Does public expectation for maximum punishment align with procedural protections decades after the offense? August 14, 2015, King County, Washington. A court clerk files an amended sentencing document in State v. Ridgway. The amendment adds 3 names, women whose remains were identified through DNA analysis conducted between 2011 and 2015. Gary Ridgway's original plea in 2003 covered 48 murders. The sentence was already final. Life without possibility of parole. The additional identifications did not alter his legal status. They altered the record. Genealogical techniques enabled some identifications. Others required mitochondrial DNA, genetic material passed through the maternal line, useful when standard DNA is too degraded. Forensic anthropologists revisited remain sites flagged in Ridgway's debriefings. He had provided general locations as part of his plea agreement. Victim-first protocols governed the process. Families received formal notification before public filing. A victim services coordinator contacted each family individually. Some had been searching for missing relatives since the 1980s. Others had assumed their loved ones were alive elsewhere. Court oversight ensured memorialization. Each newly identified victim was added to the formal sentencing record. A brief notation appeared in the amended filing: name, approximate date of death, location of remains recovery. Mitigation had been a central issue at Ridgway's original sentencing. Psychological evaluations documented cognitive limitations. An expert testified that Ridgway's IQ fell within the lower range of average. Adaptive functioning tests showed deficits in planning and abstract reasoning. The court weighed these factors against the scale of offenses. The 2015 amendments did not reopen mitigation questions. The sentence was fixed. The additions served a different purpose: formal acknowledgement. A prosecutor explained the policy in a press statement. These families waited decades not knowing. DNA gave them answers. The court gave them recognition. Modern forensic capability can retroactively enhance closure even after sentences are final. The legal system adapts slowly. Families wait. Can retroactive victim identification influence post-sentencing remedies, or is closure solely symbolic? Confirmatory DNA test report, familial match verification, March 7, 2005. Sedgwick County, Kansas. A lab report confirms DNA from Dennis Rader's daughter matches genetic material recovered from multiple crime scenes. The match is partial, consistent with a parent-child relationship. A direct sample from Rader will be needed for full confirmation. The arrest followed quickly. On February 25, 2005, officers stopped Rader near his home and took him into custody. He was charged with 10 murders. He pleaded guilty 4 months later. The confirmatory DNA test came decades after the original offenses. Rader's crimes spanned 1974 to 1991. Evidence was preserved, but not initially tested. DNA technology was unavailable during most of his active period. By the time testing became routine, the cases were cold. Digital evidence revived the investigation. Rader sent a floppy disk to a television station in 2004. He asked if the disk could be traced. The station forwarded the question to police, who falsely assured him it was safe. Metadata from the disk led to a church computer. Rader was a church council president. Familial DNA provided confirmation, but also raised procedural questions. Kansas courts reviewed whether the search warrant for the daughter's specimen violated her constitutional rights. The state Supreme Court ruled law enforcement acted appropriately. The daughter was not a suspect. The sample was obtained through lawful process. Her privacy interest did not override public safety considerations. SHU and SAMS, Special Housing Unit and Special Administrative Measures, apply to Rader's incarceration. He is housed separately from the general population. Communications are monitored. These restrictions reflect security assessments, not punishment beyond his sentence. Victim families received formal notifications through county protocols. Support meetings were scheduled. The emphasis, ongoing safety and formal accountability. Procedural precedent from Rader's case influenced later genealogy litigation. Courts balance privacy, procedural integrity, and public safety. How do courts maintain proportionality when DNA confirms long-closed convictions? Are procedural safeguards sufficient? Iowa Supreme Court docket entry. Appeal pending. July 9, 2020. Lynn County, Iowa. A courthouse clerk updates the docket in State v. Burns. The defendant's appeal is active. The central question remains unresolved, whether covert DNA collection from a discarded straw violated Iowa's constitutional privacy protections. Jerry Burns was convicted of first-degree murder in February 2020. Sentence: life without possibility of parole. The conviction rests on DNA evidence linking him to Michelle Martinko's 1979 killing. But the legality of evidence collection is under review. The procedural patience in this case demonstrates a broader principle. Evidence preservation across 4 decades enabled eventual identification. Technology advanced, investigative methods evolved, legal standards adapted, mitigation was minimal. A defense expert testified briefly about age-related factors and adaptive functioning. The court found the evidence insufficient to alter the sentence. Prosecutors emphasized the deliberate nature of the offense and the victim's youth. Victim recognition protocols ensured Martinko's memory was honored formally. The court memorialized her publicly at sentencing. Family members spoke about decades of uncertainty. The Iowa Supreme Court will determine whether the investigative method withstands state constitutional scrutiny. If the court rules the collection violated privacy rights, the conviction could be vacated. If it upholds the method, the case becomes precedent. Federal courts have generally approved covert DNA collection from abandoned items. State courts vary. Pennsylvania, California, and Maryland have each issued rulings with slightly different analyses. Iowa's decision will add to that body of law. A public defender representing Burns stated the core issue at oral argument. The question is not whether he is guilty. The question is whether the state followed the rules. The courthouse docket entry from July 2020 bears a simple notation: appeal pending. Decision expected within 12 months. Should legal frameworks incentivize faster cold case review or preserve full procedural deliberation? GED match policy update, law enforcement access. May 19, 2019. GED Match, a genealogy database, updates its terms of service. Users must now opt in to allow law enforcement access to their genetic data. The change follows public debate over privacy, consent, and investigative utility. The unknown predator tile represents cases where DNA profiles exist, but suspects remain unidentified. These cases populate CODIS, the combined DNA index system, but genealogy databases offer additional investigative pathways. Those pathways depend on user participation. Third-party consent remains contested. When a user uploads DNA, genetic relatives who never agreed to participate become indirectly searchable. Courts have issued varying opinions on whether this constitutes a Fourth Amendment concern. Privacy advocates argue investigative genealogy bypasses traditional probable cause requirements. Law enforcement counters that genealogy merely identifies investigative leads. It does not provide courtroom evidence. Confirmatory samples, obtained through warrants or consent, supply admissible matches. The procedural gaps are significant. Some states require warrants before querying genealogy databases. Others treat databases as public resources. Federal guidance remains limited. Victim-first policies apply even in unsolved cases. When genealogy produces a lead and an arrest follows, victim families receive notifications, support services activate, the formal process begins. Database logs from 2023 show thousands of active but unidentified profiles. Some cases date to the 1970s. Evidence exists. Technology exists. Legal clarity does not always exist. A spokesperson for a state attorney general's office summarized the challenge. We can build a family tree in weeks. Getting judicial approval to act on that tree can take years. The soft call to action here is reflection. How should DNA and policy interact? When does investigative utility outweigh privacy concerns? When does procedural caution become obstruction? These are questions without single answers. They require civil discussion about proportionality, procedural fairness, and victim closure. When a profile exists but no suspect has been identified, should privacy or investigative utility take precedence? Do procedural delays undermine justice, or are they necessary? November 7, 2023. A conference room in Sacramento. Representatives from multiple state attorney general offices, public defender associations, and victim advocacy groups gathered to discuss genealogy database policy. The agenda includes warrant requirements, third-party consent, and evidence preservation standards. No consensus emerges, but the conversation continues. 7 cases, 7 jurisdictions, 7 different procedural outcomes shaped by state law, available resources, and victim family input. D'Angelo, Ridgway, Rader, Miller, Rowe, Burns, and the unidentified profiles still waiting. DNA technology delivered answers, but answers do not arrive uniformly. They arrive shaped by statutes, court rulings, lab capacity, and the simple fact of whether evidence survived long enough to be tested. Life without possibility of parole appears in 4 of the 6 resolved cases. Plea agreements appear in 5. Mitigation evidence was offered in 3. Courts found it insufficient in 2. The median time between offense and arrest in these cases exceeds 30 years. For victims' families, that represents a lifetime of uncertainty. For defendants, it represents decades of freedom before accountability. Genealogy changed cold case investigation permanently. It collapsed suspect pools from thousands to 1. But it also raised questions the legal system is still answering. What is reasonable privacy? What is permissible surveillance? When does investigative innovation outpace constitutional boundaries? The final symbol is not a single ruling or a single docket entry. It is the ongoing process. Courts reviewing motions, legislators drafting bills, advocates arguing both sides. One family member, speaking at a victim impact hearing, offered a summary. We waited 40 years. The law waited with us. Justice was slow, but it came. The record remains open. Appeals continue. New cases enter the system. Evidence ages. Technology improves. The balance between closure and procedure shifts case by case, state by state, ruling by ruling. This is the story of how justice deferred became justice delivered, written in court filings, vote tallies, DNA logs, and the quiet acknowledgement of names restored to the record.